SJC-11869 and 11870, Commonwealth versus Charles Mendez and Commonwealth versus Takuma Massie.
Good morning, Mr. Neves. On behalf of Mr. Mendez, and as soon as we get the clock going, you can begin. All set, thank you.
Thank you. Good morning. May it please the court, Catherine Neves. I'm here this morning on behalf of the defendant appellant, Charles Mendez. Paraphrasing from the appeals court's decision in Commonwealth v. Warren, the dissenting opinion in this court just recently decided the case as well. Individualized suspicion is what separates reasonable suspicion from arbitrary police action. The lack of individualized suspicion in this case is the reason why Mr. Mendez's motion to suppress should have been granted. I'd like to start with the erroneous factual finding that I think is the crux of the motion judge's decision to deny the motion to suppress. And that factual finding formed the basis for everything else that follows, namely that it was quiet, unusually quiet, in Father Diafario projects after the 911 call, because the residents of this complex, which comprised 2 city blocks, 68 buildings, 300 units, were all frightened to come out of their homes.
That's what the witness said.
That's not what well, Mr. Luciano said in his area, in that area where the shooting happened, he said, nobody's coming out. He said, no, I'm not going near the car. Nobody wants to go near the car. And then Elaine goes near the car. But significantly, Your Honor, what's more important is what Trooper Shea thought, because the motion judge attributes this factual conclusion to Trooper Shea, saying that Trooper Shea concluded that it was unusually quiet because he had drawn the inference that people were afraid to come out of their homes, and then that inference led him to be suspicious of the Honda Civic. When you look at the record in this case, Trooper Shea testifies to no such thing. Trooper Shea testifies that when he drives down Beauregard Street through the center of the village, it's unusually quiet given a 911 call. He expected to hear commotion, the usual excitement with sirens, lights, action, and he didn't see that. There was no testimony about what it was like in Father Diafario Village on a November night at 6:45 in 40-degree weather. What Trooper Shea said was, I thought there'd be people out, I thought there'd be commotion. There wasn't commotion because it was a silent dispatch. In fact, the prosecutor...
Well, he realized that, Trooper Shea realized that before he made the stop.
He realized,
that there
yes.
That there was a silent alarm.
That's correct.
So he knew that before he made the stop.
Correct. And I'm going with where we begin, which is when Trooper Shea first sees the Civic.
Isn't the critical inquiry that there's a 911 call, a serious crime, and there's a sole motor vehicle around the scene that would raise suspicion?
Well, I would disagree with that in the sense that Trooper Shea sees one other vehicle at the perimeter of Father D. Before he goes into the perimeter, he calls it in. It's registered to a woman with no criminal history. That also had a male going quickly to the car. He calls it in and he keeps moving. He drives down the 2 blocks through the middle and he gets to the end where he says it's quiet and I expected there to be more lights in action, so I think it's a hoax. I don't think there's anything going on. And I turn the corner and I see, or I look and I see the Civic, and if you listen to the tape of or look at the testimony, he says, I still think it's a hoax, it's really quiet, but it's the only show in town.
Well,
but it's not the only show, I mean,
that's what I picked up, the only show in town.
Yeah, the only show in town, but when he comes in at the southwest corner, and that's where he sees the first car, and he calls it in. He goes up a block, say, and the crime, by the way, based on my looking at the map, occurs at the northwest corner. Beauregard Street is, as he testifies, at a place where he doesn't have a line of sight, and he takes a right, goes down, doesn't see anything, doesn't see any sirens, no action. This is 5 to 6 minutes after the 911 call. Comes to the end of Beauregard and Eddy Street, which borders the eastern side of the project, sees the Civic. He says, I still think it's a hoax, but I got a guy making a beeline to the back seat. It's the only show and he testifies, it's the only show in town, so I start following him.
But there's nothing,
That's following him. The beeline, the person who gets into the car takes off so fast that he's not even all the way in the car yet.
Well, I have to say, Your Honor, that's true. He says he makes a beeline, he gets in, the door is not shut yet, and the car starts going. But still, if you look at the testimony at that point, he still thinks it's a hoax call. It's as he's following the Civic.
Well, it's not as subjective knowledge, it's subjectively.
But I think he had no suspicion at that point. The reason why he was following that car is it was there. It's only as the car is traveling along, he finds out that it's not a hoax call, that someone has been shot and someone's dead. And then he gets the information about Adam Blair,
But
supposedly.
you can look backwards. So before there's been any seizure, as he's following along, he has in mind that somebody took a beeline to the car, and the car took off before he was already in. He has that knowledge before there's a seizure.
That's true, absolutely, Your Honor. I mean, but at the time, the fact that he sees that at the time does not particularly he's not suspicious of the car at that moment in time. There's no question about that.
Now, the judge refers to, I think the judge refers to it as a serpentine path.
Yes.
Is that the judge's words, or is that the words of?
That's the words of the trooper.
The trooper.
Yes.
So he refers to it as serpentine.
Yes.
Wow.
He referred to it as serpentine.
And what inference can be drawn from that? Your sister suggests that this person was trying to avoid the main thoroughfare for fear that they will be seen by a police officer.
Yeah, I'm not, frankly, I mean, I think the officer testified that that's really what, at the end of the day, that's what led him to believe that these people were somehow involved. And the testimony was that they took a right, they took a left, they kind of were weaving their way around. There was testimony introduced on cross-examination, or perhaps a trial, so I could be wrong about where this happened, that the more direct route would involve streetlights. But, so I'm not sure what you can garner from that. The officer testified they were not driving quickly. They were not driving evasively. The driver rolled through a couple of stop signs, didn't blow through them, but rolled through them, didn't use directionals. That is highly common everywhere I drive.
can I just ask a question? So it's okay to follow them, right?
Absolutely.
And while following, he found out that the other car, there was no problem with the other car?
I think he had found out before he even started following the Civic.
Okay,
If my recollection is correct.
And he knows that there was a shooting,
Yes.
and so now he's following the only car that they don't have any answers about.
The only car he happened to see in the short amount of time that it took him to drive from this side west, the 2 blocks. So I think it's distinguishable from some other cases where you can really make a strong inference that this is the only car around, particularly, time of day. This is 6:45 instead of the middle of the night. This is a trooper who did not, and he acknowledged, he did not travel the entire perimeter of this project. He happened to see this car. The appeals court case, the Quinn case, where you have a break-in in a gas station, you've got fresh tracks in the snow, a car leaving the area, and there's testimony from the officer that he goes up and down sort of these state roads, and it's the middle of the night, and it's the only car you see. you can make a conclusion there, perhaps, in that case. In this case, there was the 911 caller did say they left in a car. No description of the car, no description of what direction it went. That call came in at 6:43. The trooper, I think, called in the Civic at 6:53, 10 minutes later. So, I mean, there's, as this court noted in Warren, the time and proximity doesn't have a lot of relevance here, because at that point, if these people have left in a car, but we don't know what direction or what the car looked like, they could have gone, and this is the middle of the city, it's near the police station in Fall River, they could have gone any direction at all. So I think in this particular case, I think you take Trooper Shea at his word when he said, it's the only game in town, so I start following it. And I still think it's a hoax call, but then as I go along, I find out that there has been a shooting and someone's died. But the question is there enough to tie that, there's the corroboration that happened, to these people in this car who are not rushing away, are sort of weaving their way
Well,
through
help
Fall
me,
River.
I mean, of course, we measure whether there's reasonable suspicion at the time of the stop.
Correct.
So, help me to understand, the car stops, Mendez and Massie leave the back seat,
Yes,
and they are approaching, they see a car stopped in the middle of the street,
yes,
which is the trooper's car, because he has no place to park,
correct.
and they begin to walk towards that car?
No,
Okay.
the evidence is,
What do they do?
well, Trooper Shea testifies that the car, the Civic pulls over, and it sort of pulls over at the corner, gets sort of the last spot. Woman gets out of the front passenger seat, goes up to a house. The car, he estimated, sat there about 30 seconds. It's noteworthy, nobody ever, he testified during all the course of the driving and at the time of the stop, nobody's looking back, nobody's doing anything funny, but within 30 seconds, Mendez gets out of the back passenger seat, Massie gets out of the back driver's seat. They have their hands in their pockets the whole time. They turn and they see the Nitro parked in the middle of the road, which is parked there because Trooper Shea said there were no other spots, so I just sat there and I hoped they were going to keep going. And he said that they stood there frozen looking at me with their hands in their pockets the whole time. 2 to 3 seconds go by. I'm worried for my safety. I get out and say, police, don't move. That's the timing.
Now, you can understand why he would be concerned.
I do understand why he would be concerned, but I don't know that he's, this is the kind of situation where you've got to have the reasonable suspicion before the stop.
Does he know it's a shooting?
Yes, he does.
So it's a shooting case, he has two people, and their hands are in their pockets when they get out of the vehicle.
The hands are in their pocket. There's no indication that they put their hands in their pocket.
Well, either way,
There's-
he's sitting in a car by himself, two fellas get out of a car with their hands in the pocket in the aftermath of the shooting.
Correct.
Are there safety concerns?
There certainly are safety concerns. I think he genuinely thought there were safety concerns for himself. The question is, did he, without the objectively, just the reasonable suspicion, did he put himself in that position? He's obviously a good officer. He had a darn good hunch. But you're in a situation where you know you don't have your vest on, you know you don't have backup. Why do you stop in the middle of the street? Why not pull around? If they don't, he indicates, if you listen to the tape, he tells dispatch,
When does the stop occur according to your analysis?
7 o'clock.
No,
It
no,
stops when he says, police, don't move. That's
After
when the stop
When he
happens.
sees their hands up.
Pardon?
When he sees their hands in their pockets, right?
Well, their hands, he said, their hands are in their pockets the whole time.
But let me ask you something. The trooper had every right to follow this car without asking it to stop.
Absolutely.
And every right to park in the street.
Sure.
And then when
sure.
they get out, then he says safety concerns and tells them to stop at that point.
Well, I think the question is, is there anything in that series other than he's following these people along and there's a serpentine route? Is there anything that says that these people are the people? If he does, then that's the end of the story. If he doesn't, then he induces the conduct, you can say you've induced the conduct that creates the reasonable suspicion, because now they get out of the car, it's 40 degrees, they've got their hands in their pockets. Other cases, that talk about why that matters, hands go in, you see a bulge, there's a straight arm, there's nothing, they just hands in their pockets the whole time.
But is the concern that they're stopping and staring at him for some period of time?
He said 2 to 3 seconds. They didn't do anything. They stood frozen looking at him. He said that they were talking, but again, he said it was 2 to 3 seconds.
Okay, thank you.
Thank you.
Good morning,
Good
Your Honor.
morning.
Jennifer O'Brien for the co-defendant Takuma Massie. I'll kind of pick it up where my sister left off. And I think it's important that we look to the actions of the defendants when determining whether or not their actions were suspicious, not necessarily the predicament that the police officer found himself in. He's a good police officer, no doubt, but to allow this behavior would be to put a rubber stamp on cases where there's an off-duty police officer who makes an arrest or pats somebody down, and it's saying that off-duty police officer or off-duty police officers don't have to provide defendants with as much constitutional right as a police officer who is in full uniform, who does have his police radio, who is in a cruiser, who is readily identifiable. Because the police officer put himself in a dangerous position, and rightfully so, it doesn't mean that the innocuous or otherwise innocent actions of the defendants were more suspicious than would be the case if he was in a cruiser.
But if we find it to be a dangerous position, to start with your first premise, if we find it a dangerous position, hasn't this court said in the past that police officers can take steps for their own personal safety? Yes,
and I would argue he perceived it as dangerous because he didn't have backup. But when you look at I would argue it wasn't dangerous based on what the defendants did. The defendants here didn't reach for their pockets or put their hands in their pockets as soon as they saw the police officer. What they did was reasonable. It's a dark, fall, cool night, and they get out of the vehicle, and there's a car 2 to 3 car lengths behind them with their lights on and illuminating, just looking at them. So a reasonable person would look at the car behind them. There was no testimony that they made gestures toward the police officer or yelled at him or asked who he was or made any movement at all. The police officer testified that they were frozen. They stood frozen for 2 to 3 seconds, and he came out of the car. If there was any movement or advancement toward the officer, I would agree with Your Honor, that's a dangerous situation. But here, they were just wondering who the heck it was that was sitting in a running car with their headlights illuminated on them.
But you agree that the officer had every right to follow them and stop in the middle of the road?
To follow them initially? Yes, absolutely.
And to stop in the middle of the road?
And for him to stop his own car in the middle of the road? Yes, they asked if it was a one-way street, and I believe Trooper Shea was unaware as to whether or not it was a one-way, so we can assume it probably wasn't. There was no testimony that he blocked the vehicles in, the other vehicle in. This was, it's at the time that that Trooper Shea made the stop, he had what he knew was that somebody had been shot, that there was someone in a car that was around the general area, and that they were driving slowly, I would argue casually along, and they got out of the car. I mean, that's pretty much it. And you have 2 people that are just standing in the street who look at a car with its headlights illuminated. And I argued this in my reply brief that the way they drove, the Commonwealth is arguing that that's somehow suspicious. But they can't really have it both ways. I think if there was testimony that the car took off on 2 wheels and was speeding through intersections to get out of there, that would arguably be another factor that the court could consider, but it's the opposite, that someone would shoot somebody and drive leisurely away. You would assume somebody would want to go from point A to point B as fast as possible. With respect to the high crime area, which is something that the motion judge relied on, you know, you look at Trooper Shea, he was the only person who testified as to whether this was a high crime area, and he did say this was, it was a high crime area, anything from felonies, misdemeanors, et cetera. But when he was asked on cross-examination whether he had personally conducted any investigations in that area, he admitted that he never had. There was no testimony that how he found out this was a high crime area, whether that be from reading police reports or talking to other police officers. And I would point to the Commonwealth versus Johnson case. It's not in my brief, it's a 2009 case, and it basically says whether or not a high crime, something is a high crime area depends on the specific facts by the trial judge, rather than just a label that somebody puts on it. And here, there was nothing to support that this was a high crime area. He testified that he did serve warrants on people at Father D Village, but never that he was involved in any investigation. So these crimes could have happened anywhere, and the people were served with warrants there.
Now, what is the consequence to the fact that he certainly could have stopped that car from going through a red light?
Well, he didn't. So,
Right.
and
Well,
that's my...
But he didn't, okay.
And his testimony said that it didn't raise suspicion that, I think it was a stop sign, I don't think they went through a red light, but they did roll through
Right,
some
through
stop
stop
signs. And he specifically testified that, and I'm paraphrasing, that it wasn't a big deal, that didn't necessarily raise suspicion to him because people do roll through stop signs regularly, that he had no intention on citing them, and he never cited them. So once the defendants come out of the vehicle, they are pedestrians on foot. You can't tell them to stop and say, well, you were in a car that rolled through a stop sign 500 yards down the road, so let me see your ID.
Well, hold on, but if there's constitutional justification to make a civil motor vehicle stop, and it seems like uncontested that there was, and the officer has a right to go up and inquire of the driver, and two people come out of the car, doesn't the officer have a right to stabilize the situation? In other words, it's not what subjectively is going on in his head, it's subjectively, is there a constitutional justification for what happened with trying to stop the passengers getting out of the car?
Well, again, I would argue that that's not the facts, but yes, if he was going to make a motor vehicle stop and people jumped out of the back seat, he could certainly stabilize the situation.
But what's not the facts? I understand it wasn't argued below,
Yes.
but I've had the same thought Chief Justice Gantz had, which is about there was a right to inquire of this operator.
Well, I would say there could have been a right, but that he didn't inquire of he didn't inquire of the operator. That wasn't, he testified that he was never going to cite the people, the operator. So, I mean, those aren't the facts of the case, and I think we have to look at what he actually did and what actually happened in the case. And he didn't make a motor vehicle stop, and that was, you know, a main point in my reply brief, that this isn't a motor vehicle stop, because a motor vehicle might have done something 3 miles prior to give the police officer cause and justification to go and ask the driver for the license. It didn't happen in this case. There was no testimony as to how far back, he rolled through the stop sign, so, it's speculative. But to follow somebody for 4 miles when they, rolled through a stop sign 4 miles previously, it wasn't argued down below, and I would argue that, we're stuck with these facts, and once they get out of the car and they're standing there, it is a pedestrian stop. And I think that's what the judge found down below. She didn't, even though the Commonwealth did make such an argument, she didn't get to it.
So what does the law require this officer to do?
In this situation?
This situation.
Well, I think he has to either wait for backup. I don't think anything necessarily happened that made it necessary for him to effectuate a stop. If the police, I'm not arguing he should wait till somebody pulls out a gun and starts firing at him. Here, where you have two people, literally, the testimony was frozen, just staring at someone, I would say any movement whatsoever, he could jump out of the car and say, stop, police. There was no movement, no yelling. If they said, what are you doing, what's going on, who are you following us, anything like that, I would argue would be enough. But here, just to stand like a statue and look at someone for 2 seconds in the dark, that's not enough. There was no testimony as to how many people were involved, whether they were male, female, the race of anything. So he had no identification as far as the car was concerned. He had that someone was shot. These people were around the scene at the time, and they were driving slowly out of there. And then they got out of the car and looked at him.
Now, do we take into account, as we did in DePina and Santos, that what is reasonable may differ depending on the severity of what's at stake, which in this case was a murder, and the possibility that these folks who had just killed, maybe if they were the right people that just killed somebody, could be potentially seeking to shoot a police officer to escape?
Yes, absolutely, Your Honor. But I think you just need something more. There's not even a vague description of who these people are. And there was no escaping. There was no testimony that they were looking back to see if anyone was following them, or they were, driving abruptly away. They were on a Sunday drive, as far as, Trooper Shea testified, which is the complete opposite conclusion you would expect from someone who had just shot and killed someone. With respect to the border probation record for Adam Blair, I raised this in my reply brief, but the police officer, Trooper Shea, was told while he was driving that there was nothing with the owner of the car. And the owner, it is in the transcript that the owner is presumably, and there was no testimony, Adam Blair's father. It was a white man in his 60s with no record. But Adam Blair, who we are inferring might have been his son, was known to associate with that address. This is something the Commonwealth kind of hangs their hat on as far as, the potential dangerousness. Here it would be anticipated that the owner of the car would be driving, and the owner is a 60-something-year-old white male with no record. Adam Blair, if you look at his border probation record, has no convictions. There is a firearm charge that was 4 years prior, and there was an open drug case at the time. There was no testimony that he was still present at this address, that he was ever drove this car or was involved or associated with this vehicle. When the defendants got out, which I argued in my brief, it was clear that neither one of them was this particular person. If you use the collective doctrine, the collective knowledge doctrine. So the fact that the Trooper Shea, didn't follow the first person that it was a 50-50. There were two cars, essentially. There was a white male in a hoodie hurrying quickly to a vehicle. He didn't follow that car. He followed the second car, which was gender and race unknown, in a hoodie, entering quickly into a car. So, to say that someone at this address who didn't match the description of either defendant and wasn't necessarily likely to even be driving the car gave him, the reasonable suspicion to pull him over, I think is quite a stretch. The motion judge also uses that they were whispering in the back seat, the defendants. And I think the Commonwealth concedes that it's really of no consequence. There's no testimony, no evidence that he ever testified they were whispering. We don't know that they were whispering. There could have been a loud radio and they could have been talking. And there's nothing to support that necessarily, they would be involved in the crime and the driver wouldn't be involved in the crime. So because they were whispering, somehow it's more suspicious.
Didn't he think that they were hugging, but then when they get out, he's thinking perhaps that they had been talking to each other before he says, "Please stop"?
He testified that they were talking the whole way. He testified when they came out, he heard discussion, but he was unable to hear it wasn't loud, he wasn't able to hear what they were talking about. So 2 to 3 seconds of probably, who's this guy, you know? He didn't hear anything. I'm obviously, you know, supposing what they said, but there was no testimony about what was said. I don't know, I don't think I have time for any of the other issues, but I would ask you to consider all the issues, obviously. And I would note that if, you know, if the defendants do win in the suppression case, you know, this is a case that can be retried. There was other evidence besides the firearm and the money, which obviously would be suppressed if Your Honor found in the defendant's favor. Thank you.
Thank you. I'm not sure whether it's still morning, Ms. Cho. An issue in dispute.
Yes, good morning. Yulmi Cho for the Commonwealth. I'll start with the motor vehicle stop, whether the significance of the motor vehicle infractions. I don't know if that necessarily gets us around having to show reasonable suspicion, because I think if Trooper Shea had stopped the car for the infractions, then that would get us stop long enough to cite the driver for it. For an exit order or a frisk of the passengers, we would need some sort of furtive movement or some sort of reasonable suspicion to believe that these two were armed and dangerous and posed some level of threat to the officer. So we still need reasonable suspicion at that point. So it doesn't get us any more than the stop of the car, which occurred by itself. So that is why I didn't dwell on it in the brief. But of course, if Your Honors were to find otherwise in our favor, I would be perfectly happy with that. No one piece of evidence in this case gives us reasonable suspicion, but each piece of the evidence that we put out in the brief lend itself to reasonable interpretation that these two defendants were involved in the murder at the Father Diaferio housing project. And of course, innocent explanations could be had of each piece of evidence, but pulled together, we have two defendants found at the housing project where we would expect the murder suspects to be found, and then they travel through parts of the Fall River in an evasive manner. The serpentine route that they took, there was much discussion back and forth about how to properly characterize this. But beyond all of that, the testimony was that the defendants took, the Honda Civic, took 15 separate turns, and the total length of the route that they took was about twice longer than a more direct route that did exist, meaning some of these left and right turns were unnecessary, and we can reasonably infer that some of these turns were taken to be evasive, either to avoid some major thoroughfare where they may by chance encounter the police, or to maybe lose someone who may be following them. One way or other, the purpose behind these unnecessary turns could be because they're coming away from just having committed a murder.
And did the trooper ever articulate what meaning he gave to the serpentine path?
I do not believe so, but his subjective perception of what this could have been is not necessarily important in this case. I believe he attempted to say this was an evasive or meandering path. So he tried to characterize, he initially tried to give testimony that with a characterization, but I think after being objected to, he then ended up with the serpentine. I think he may have initially used the evasive, the adjective evasive, but after being objected to, I think he then changed to serpentine. So I think to the extent that he tried to convey a subjective intent, I think that is somewhat there. In terms of the Civic being the only other car other than the first car that was excluded as a possible suspect, that is significant. When the trooper drives through the middle of the housing project. He says that he drove through the whole length of the project, from the western border to the eastern border, right through the center. He drove with all the windows down, looking left and right, trying to look for and try to hear for any possible suspects, and he didn't see a single thing. So whatever the reasons may have been for the residents to stay inside, really what we have that we have is that no one else was out. So if the Civic is the only other car, other than the car that was excluded, that's out, that is more likely that that suspect is riding in this car, as opposed to if there were 5 or 6 other cars fleeing the area. So I think
This was 10 minutes later when he stopped them, right?
yes.
So I don't know the size of the area, but they'd have to do a lot of meandering to still be in the area 10 minutes later, right?
If they were in the car immediately after, which we don't know, then possibly. But we don't know that the suspects took off from the scene immediately. We don't know if they did something in the meantime, maybe to get rid of the gun or something. So we don't have to exclude the possibility that these 2 suspects were a little closer to the.
Did the trooper testify to how long it took him to follow this vehicle?
The total length of the.
As Justice Hines pointed out, it was as a 10-minute stop from the time of the 911 call to when the vehicle stopped, correct?
On Kellogg Street.
Right, but how long was it that he was behind this vehicle? Do we know?
Not more than 20 minutes. I believe it's 10 to 15 minutes, not much longer, but I can't recall exactly. But I think it's not 10 minutes between the 911 call and the trooper calling in, I see a Civic, I'm going to follow it. I think it's actually 8.5 minutes.
8.5 minutes.
Right, which is not, it would have been better if it was 3 minutes in a closer proximity to where the murder occurred, of course. But it's still smaller than, for instance, in Warren, where about 30 minutes passes and the radius of where the suspects could be found is much greater. We have only 8.5 minutes, and our suspect that Shay sees on foot. So I think a person moving on foot obviously is traveling at a slower rate. So I think it is reasonable, especially considering that there's no other person, to find that this person may be the suspect. It's of course not by itself enough to get us reasonable suspicion to believe that he is the one, but it is part of our reasonable suspicion calculus. And where there's no one else, I think it was correct for Trooper Shea to begin to follow him, although not stop the vehicle. At the moment that the car comes to a stop by itself, I just wanted to lay out the facts a little more step by step. The car comes to a stop in front of a blue house and pulls over to the curb, and it goes into a space. And then Trooper Shea stops behind it in the middle of the street, about 2 car lengths behind it. About 15 to, a female front seat passenger comes out and goes into a house. At that point, Trooper knows that there are 3 people in the car, one of them possibly Adam Blair, maybe not, but he can't exclude that possibility at that point. 15 to 30 seconds after the female goes into the blue house, then the defendants come out of the back seats. The driver remains in the driver's seat. The 2 come out simultaneously. The 2 turn their attention to Shea simultaneously, and they're talking to each other. And knowing that this car came from the housing project where a murder just occurred, the fact that they have their hands in the pocket, Trooper Shea can't exclude the possibility that they're holding the same firearm that they had used to commit the murder. At that point, combined with the other facts that are contained in the brief, it was reasonable for Trooper Shea to stop the individuals at that point. If there are no other questions regarding that, I'll just quickly touch on the joinder issue. Even though in the second episode of the armed robbery, murder occurred, so that is a big distinction. But going into the two armed robberies, there are numerous similarities between the two, and the timing of the two offenses, the episodes were so close in time that it was correct to join these two indictments. The cast of characters involved in the two episodes were the same. The same set of defendants as partners in crime commit the two episodes. They target the same type of victim. They have the same getaway vehicle, and their MO seems to be to set up a meeting over the phone to commit an armed robbery of the small-time marijuana dealers. And also, there's no break between the two episodes. The Ryan Moitoso firearm, the armed robbery wraps up around 6:11 p.m., according to the phone records. And at 6:17 p.m., Charles Mendez, Takuma Massie is already making phone calls to Platts to set up their next meeting. And they travel directly from the first armed robbery to the second. So there's no break. And the two episodes take place within 32-minute window. I think that joinder was properly, the joinder motion was properly allowed.
If I can go back to
Sure.
one matter which your sisters began with, they are correct, aren't they, that the judge probably erred in inferring that that you can make the inference that everybody was afraid to go out, and therefore the only people who were out were likely those persons who might have been involved in the shooting, as opposed to it being very quiet because there weren't the usual torrent of police cars approaching the scene of a shooting.
So in my brief, I don't rely on that finding for our analysis, but I don't think it's clearly erroneous. When the 911 caller, Luciano, called in, he said no one is coming out. Of course, he can't speculate as to what other people are thinking, but he does see that no one is coming out. He's out, but no one else is coming out. On top of that, the corroboration is Shay's observation is that no one is out. So I think on that, it's not clearly erroneous, but it's not something that we rely on in our calculus.
So as far as I can tell, what you really rely upon is the fact that the car, when he sees the car, it is moving, they're leaving before the door is even closed. The serpentine path, the stopping and the staring at the police officers, those are the things which you say combine together to form the reasonable suspicion?
Yes, plus the criminal history
I'm
of
sorry.
Adam Blair. And let me just check my list. Yes, I mean, each piece of the evidence, I think we can break down to have more meaning, but I think that would be the
Those are the four
list.
things.
Yes.
Thank you.
Thank you, Your Honors.